Good morning, everybody. Good morning. Good morning. We're going to give this just another minute because I see a lot of people in the waiting room getting loaded up. Good morning, everybody.
Good morning.
Good morning. We're gonna give it one more minute, and then we'll get the ball rolling because I see people still coming in. All right. So welcome, everybody. I am so excited that you all are joining us today on this Thinking Differently. We're going to talk about the latest trends in background screening, and we're going to do this a little bit differently. I want you to ask questions in the chat as we go along, right? I want this to be a little bit interactive if we can. Um, my name is Kevin Vonderlippy, and my job here at Catapult is I'm the Director of HR Products and Technology, and I oversee our background checking business. Uh, if you don't know, Catapult does background checks. Uh, Catapult wholly owns a detective agency that's been around for 58 years. And for the last 28 years, I've run that detective agency. Um, just a quick disclaimer, I am a private investigator, not a lawyer. So this is not legal advice. So we're gonna cover a few things today. We're gonna just uh, talk about concerns around background checks. We're going to talk about the compliance part with the Federal Fair Credit Reporting Act and Title VII of the Civil Rights Act of 1964, and then things that are on the horizon. Like I said, if you got questions, please put it in chat, and that'll be relayed, and we'll try to answer it. Okay. So, why do you all do background checks? I mean, I would love to know if you have a reason that's outside of this. Please put it in the chat. But companies do background checks basically to protect the company, right? They want to protect the employees and their customers. They want to use it as a screening tool to pick better applicants, and of course, protect the company's reputation. Sometimes reputation can be destroyed in a second by a bad hire. And there's plenty of examples that we can see right here in North Carolina or South Carolina where that's happened. Um, these statistics came from a nationwide survey from the PBSA, which is the Professional Background Screening uh, Association. And so for most people, when it comes to background checks themselves, one of the biggest concerns are turnaround time, right? 62% of a recent survey we did said that that was the most important thing, right? And unfortunately, sometimes the need for quick turnaround times uh, conflict with accuracy of your report, and so that's something that you have to balance. Um, accuracy in my mind is paramount. Um, So how do you impact those? How do you have a positive impact on turnaround times if your background checking company is doing primary record research, let's say? Um, maybe you look at when do you start your background checking process, right? The best practice has generally been after a conditional offer has been issued. And that best practice is in place because there are some locations that have ban the box or second chance laws that impact when you can do a background check. In North Carolina and South Carolina, and even all of the surrounding states from us, there there's no restriction on you doing it pre-offer, right? Um, However, there are considerations with that, right? You want to make sure that you're uh, doing this in such a way that you're being consistent and not spending money on people that really don't have a chance to be your employee. Ease of use is always uh, a big concern too, right? And today there's lots of things that are moving to make this easier. You know, these applicant tracking systems and HRIS systems have integrations. Their background checking companies use mobile friendly sites. Um, you know, you don't have to have your own staff do the data entry. You know, that can be done in combination with your applicant tracking system or the applicant themselves. And of course, along with that, there's a lot of automation stuff. But there's downsides to automations. I mean, we know as of October last month, just a few weeks ago, the Consumer Financial Protection Bureau came out with very strong opinions around the use of automations in the workplace and how they impact your applicants. So something to really uh, keep in mind. We don't have all of those rules out yet, but we know that there's already court filings. And I would tell you another big concern is compliance. I mean, that's from a liability standpoint, it is real, but it is something that you can overcome, and we'll talk about all of those today to help you stay compliant. Joni, were there any questions in the chat that need to be addressed?
No, not yet.
Okay, perfect. And so speaking of lawsuits, you know, we are living in the world of AI, and this one's from this year already against Workday. And it speaks to how the algorithms of Workday screen or pre-screen applicants. And so I think this sort of litigation, coupled with what the CFPB is doing, are going to make a difference. Rules are not out, of course, quite yet from the CFPB. Here's a chart that was compiled from data from Web Recon on Fair Credit Reporting Act complaints. And it's not on my chart here, but if I would have included ground zero would be over about 2008. Started with a Fourth Circuit case. Fourth Circuit, of course, is the federal courts here in North Carolina, South Carolina, West Virginia, Virginia, and Maryland. So what happens in the Fourth Circuit's ours, right? There was a big case in 2008 that was about a 21 or $22 million case that really got the lawyers interested in the Fair Credit Reporting Act type of lawsuits, class action lawsuits in particular. There are currently no caps on a Fair Credit Reporting Act class action lawsuit. So a little unusual for federal law. And so you can see that this has just jumped up. Um, we see a slight downtick last year. My belief is that that is not a trend. I think that is a result from cases that happen in that 2020, 2021 period. They take a long time to get ready to go to court and be filed and all that. And so I think that slight downtick is a COVID result. But we can see what's going on right now. Uh, there doesn't seem to be any shortage of new filings. So, what is the Fair Credit Reporting Act? The Fair Credit Reporting Act at its core is a privacy law to protect people in America, right? And it doesn't matter really where it is. If someone's collecting information about you, the Fair Credit Reporting Act was designed to protect you. It has got some very specific ramifications in the employment realm. And so, with a lot of extra hoops, if it is an employer looking at an applicant or an employee, and so anytime it touches a third party, so this employer engaged with a third party to get information about an applicant or an employee that's going to impact their employment, then it's going to fall under the Fair Credit Reporting Act. Today in 2024, it is almost impossible not to fall under the Fair Credit Reporting Act, right? Because everything involves third parties. And we even have seen something that looks like direct source information like US Department of Transportation stuff, right? The Attorney General saying that because DOT used a data broker to provide and organize their data, that falls under the Federal Fair Credit Reporting Act. So there really is no escaping this uh, for most uh, for most companies. Um, so anytime you touch a third party, it's going to be under the Fair Credit Reporting Act. Background checking companies are what's called consumer reporting agencies or CRAs. Not the same as a credit reporting agency, but close, right? And so a consumer reporting agency might report on financial credit file stuff too, but there's really only three credit reporting agencies. That's TransUnion, Experian, and Equifax. If you, HR, are calling another company to company, and there's nobody in between, that is not an FCRA event. So if you call another company and talk to their HR to get a reference, that's not an FCRA event. But if you hire Catapult to do it, then it is. Does that make sense to everybody? All right. So how do you stay clear of the pitfalls of the Fair Credit Reporting Act? I will say that this is probably one of the most common questions we get asked. And I'm always surprised at how many people are afraid of doing background checks because they think that this law prohibits them from doing it. You're not prohibited from doing background checks, right? Background checks are a good, reasonable part of your screening process. Um, but there are some steps that you have to follow. And the good news is with the Fair Credit Reporting Act is it's just paper, right? You just have to follow these steps, and you will be fine with the law. You have to have permissible purpose. It's always going to be employment with you. You have to have written permission, right, before you engage with the background checking company to do the background check. That makes sense. The Fair Credit Reporting Act is a privacy law, so you got to have permission. And then you've got to be able to show that you have permission. Most people believe that you ought to hang on to your release forms for some period of time beyond just immediate. The law has a 6 year um, window, or really little less than 6 year window for statute of limitations. Um, Most companies don't keep them 6 years; they keep them 2 or 3 years. Um, the balancing there being where your liability is, right? And your liability may be more with a class action that can be generated by keeping these release forms for long periods of time. So before you start your background check, you have permissible purpose, you get the signed release form, you engage with your background check company, report comes back. If the report comes back clean, meaning there's nothing negative in that report, you're done with the Fair Credit Reporting Act. Nothing else you need to do. If the report comes back with something negative and you look at it and goes, who cares, right? Let's pretend, for example, your applicant has been convicted of fishing without a license. Uh, who cares? Unless you're hiring a lake warden, it's probably not job related, right? And so if you get something back and you don't care about it, then you hire the person. You're done with the Fair Credit Reporting Act. So if the report's clean, or if you hire the applicant, you're done with the Fair Credit Reporting Act. However, if the report comes back and it's got something negative in that report, and that negative information is giving you heartburn, then you have a few more steps that you have to go through, right, to comply with the Federal Fair Credit Reporting Act. And so, like I said, this is a privacy law. It's also an accuracy law, and it just wants to make sure that you're using the information against the applicant or the employee that's correct, right? And so if you get a report back from Catapult and it's negative information in there and it's giving you heartburn, you have to send a copy of the report to that applicant. You have to give them a copy of their summary of rights under the Federal Fair Credit Reporting Act, and you have to give them a pre-adverse action letter. A pre-adverse action letter says, "Hey, applicant, we've hired this background checking company to compile this report for us. We're going to use this in making our decision, in whole or in part, in making our decision. If you think something's inaccurate, reach out directly to the background check company. Here's their name, here's their address, here's their toll-free phone number." Right? So the summary of rights is something that is now currently managed by the Consumer Financial Protection Bureau, and they change it not often, but they change it about every 4 or 5 years. Our newest version uh, went into effect this year. If you haven't updated your summary of rights, if you'll shoot me an email, my email will be at the end. I'm glad to send you a current set. All right, your background checking company should have taken care of that for you. All right, and of course, some states have some additional information. Are there any questions, Joni, at this point on this?
We do have one question. Is an application stating that a background might be needed, is that acceptable?
That's a great question. And so please, as you get questions, please ask them, because this is a fantastic question. And so you would think that if you have that in your application that you've gotten permission. However, the courts and the Federal Trade Commission, which is the other agency that has control over the Fair Credit Reporting Act and enforcement, have clearly said that no, it has to be a standalone document that is separate and apart from everything else. And the reasoning on the standalone document is that they don't want to confuse the applicant or your employee on anything. They want it to be super clear that they are giving permission to do a background check, right? And so the language on those release forms are very regulated, and must include notice that the person is going to have a background check done on them for employment purposes, and then get their authorization on it. There are all sorts of lawsuits on this. The general thinking now, after many years of litigation, is that you can have one document do both, give disclosure and authorization, um, and but it's got to be free of everything else that's extraneous. And so you can't have, let's say, your release form and also um, other things buried in there, like waivers of their rights, or other ancillary sort of comments about uh, that they're working at the will and pleasure of the company and things like that. So you just got to keep it very clean. And once again, I'm glad to help you with that. My email will be at the end.
And Kevin, does that release form come from the background checking company?
Great question. So a lot of background checking companies are very allergic to providing that stuff because they don't want to be legally uh, liable for what you use. What they offer many times is a sample that you can incorporate and use yourself. Now, Catapult obviously is different in that we're here to help you, and so I do have release forms that I'll share. We still call it sample, but uh, I'm very free and willing to share it with you. And so we believe that our release form is the correct version, right? I mean, we've spent a lot of money with attorneys and reviewing it. So feel really good about it. Great question. If you're using a background check company, um, I would make sure that you ask them for this stuff and see what their answer is. If they're not willing to help you, then maybe it's time to find a better company. So you have a permissible purpose, which is employment. You got a proper release form. You engage with your background checking company. The reports come back, and now there's something that's giving you heartburn, right? What's your next step? Well, by the Fair Credit Reporting Act, you have to pause your process to allow the applicant a chance to review the report and respond and dispute anything that may be inaccurate. The world has changed since this law was written, right? The original Fair Credit Reporting Act came out in 1970. It was revised, and the new part came into effect in 1977. I'm sorry, that's not right. 1997, right? And since 1997, you have all the employment stuff. But that back then, everybody was mailing things. Now these things can be distributed instantly by email or through some other web links. Um, but the way the law was written and the way the Fourth Circuit has ruled on this is that you got to give them enough time. And the whole country pretty much believes in 5 business days, right? And a business day being Monday through Friday when there's mail. So if you send out your pre-adverse action packet, which is your copy report, summary of rights, and pre-adverse action letter, on Friday, yesterday didn't count because yesterday was a mail day. So there was Saturday, Sunday, and Monday would not have counted in your 5-day window, right? The Fourth Circuit judge said you had to take into consideration things like the weather and how far you're mailing your document. So if you're mailing this to some place that has a hurricane, you certainly want to add to it, right? So if you're sending this to, um, I don't know, Black Mountain, they're still suffering from the aftermaths of a hurricane. It's going to extend your 5 business days probably into weeks, if not longer, right? Once again, as members of Catapult, you don't have to struggle with this. If you have questions on this, you can pick up the phone and call our advice team, right? They're a large group of people who have tremendous amount of HR experience that are willing to help you. Or you can pick up the phone and you can call me. My phone number will be at the end of this thing. All right. So after your 5 business days, then you can make your final decision. And then there's one more step, and that is you have to provide them with an adverse action notice. It's that adverse action just says, "Hey, applicant, regret to inform you no longer a candidate with our company. If you think something's wrong, please contact Catapult. Here's your toll-free number, their mailing address. Remember that the background checking company didn't make the hiring decision, right? So, if during this process an employee disputes something, right, with you, you should take notes and you should notify the background checking company immediately, right? You should always refer them to the background checking company. But we have seen some cases in some active court uh, arenas that have dinged employers for making it hard for the applicant to dispute the results. Right. So I would say if someone tells you something's wrong, you need to refer them to your background checking company, right? Which is all that information is in that pre-adverse action letter. And then I would reach out to the background checking company and give them a heads up too. Right. So you can say you've done your part. Right. So after that reasonable amount of time, the adverse action letter goes out. Basically, that's just a declination letter. Are there any questions on the Fair Credit Reporting Act? We're going to alter your steps here in just a second on how to do this. So stand by.
Nothing yet.
So the second part that you have to worry about is what's enforced by the Equal Employment Opportunity Commission, right? The EEO. and that is the Civil Rights Act of 1964. And there's two ways you go afoul from this, right? Disparate treatment and disparate impact, right? The disparate treatment thing is that you got to treat people in a similar situation the same, right? Doesn't mean you have to do the same background check for every job in the workplace. It doesn't even mean that you have to do a background check on everybody in the workplace, right? But if you do it for one truck driver, then you got to do it for all your truck drivers. And you got to do the same. You got to treat them the same in that group, that category, that classification, right? So, but your truck driver's background check and your office personnel background check may be different. That's fine, right? You would think that in this day and age that people wouldn't have too much problem with this, right? Hopefully, nobody's out there saying, I'm going to do background checks on black men only, right? If you do that, you're going to get sued and you're going to deserve it. Don't do that. But it is shocking how many companies get nailed for this disparate treatment, not because they're doing something that boneheaded, right? But because they don't treat people the same all the time. And the example that I always use on this is if you have a owner and they come into you and say, hey, my daughter's boyfriend's out in the truck, put him to work. You can't circumvent the rules for that person, right? Because now you've treated somebody differently and you've opened up the pathway to get sued. I'm not saying you can't make exceptions, but you ought to put them through the process. Does everybody, is that clear? The next step is a little harder to wrap our brains around, and that's disparate impact. And that's where you could have what you think is a benign policy, but it has unintended consequences. And by that, I mean it artificially shrinks your candidate pool of people who are protected, right? Have protected status. And the example the EEOC gives on this is if you have a blanket policy that says, we're not going to hire anybody who's convicted of a felony, right? On the face, that seems reasonable. But if you look at the statistics, uh, in particular, black men and Hispanic men are arrested and convicted of felonies at a much higher rate than the regular population. Some of them, like if you focus it to like felony drug convictions, it can be as high as 17 times more. All right. So how do you guard against having unintended consequences based on your policy? And the best way to do that is to make sure that what you're looking at is job related, right? Job related. And so all this has been around since 2012, all this guidance. And so we know that the courts are on board with it, right? And so the EEOC has said for a very long time that you have to look at the nature and gravity of the crime that the applicant was convicted for, how much time has passed, and the nature of the job, right? This has been around forever and really stems from almost a 50-year old case, right? Which was Green versus Missouri Pacific Railroad. And out of that court case from 1975, we get what the EEOC calls the green factors. And the green factors are just what we just talked about in that paragraph on the slide before. What,
All
what
right,
was
I got a
the,
question, Kevin.
okay.
So a large portion of our candidates are under age 18. We've considered not running background checks on those candidates because nothing ever comes back on the background and it would save on cost. Can we do that legally?
All right. Great question. I'm going to pause that question for 1 second and I'm going to hit it in just a second. Okay. Great question. So when it comes to the green factors, it's just what we talked about: the severity of the crime, how much time has passed, and how does it relate to the job, right? And so if you're using these green factors, you're halfway there. You're halfway there to being compliant, right? And in their 2012 guidance, the EEOC said you got two choices. You can validate criminal conduct, or you can do what they call a targeted screening, which is the green factors plus an individualized assessment. There's no way to do a validation for every criminal conduct that's on the books. North Carolina is a common law state, which means not everything is reduced to a statute, right? There's no law in North Carolina that says you can't rob a bank. But if you go rob a bank, they will arrest you, right? And they will charge you with common law robbery, right? Because you're supposed to have enough sense not to go rob a bank, right? So impossible. You think there's over 2,000 statutes in North Carolina, plus being common law, and then you'd have to validate that for every job description, and then you'd have to multiply that by 50 states. It's impossible. So that only really leaves you with doing the green factors in an individualized assessment. An individualized assessment is an opportunity for your applicant or your employee to explain what's in the report, right? And basically, it's an opportunity for them to show you or convince you that um, they're reformed, right? And so, if it was me and I'm doing a background check, I have permissible purpose. I got a proper signature. I've engaged with background checking company. I get the report back. I now have heartburn. I send out the pre-adverse action letter. Then my next step is to enter into the individualized assessment. So I've just sent out the copy of the report, summary of rights, and pre-adverse action letter. Then what I would do is I would call the applicant and say, "Hey, applicant, I've just emailed you a copy of the report. If you'd like to explain what I see in it, I'm glad to schedule time with you." Of course, they're going to want to talk now, which is great, and you give them a chance to explain. And essentially, that conversation is going to go one of two ways. It's going to either make you feel better or it's going to make you feel worse, right? It's going to make you feel better or it's going to make you feel worse. If it makes you feel worse, that's sort of the easy button. You thank them for their time. You tell them you got something to think about. And then uh, after you're done with the conversation, then you can send out that adverse action letter, that declination letter. I'd probably wait at least a day after the conversation. But if you wait the full 5 business days after that, you're golden, right? If they make you feel better, right, then this is also awesome because now you're going to be able to maybe expand your candidate pool and give someone a second chance. And so what I would do is I would ask for some sort of proof that they're reformed. And that can be individual recommendations from counselors, religious leaders, civic leaders, community leaders, politicians, all that stuff counts. Not their mommy, but anybody of note that can speak to the fact that they've grown as a person and they're changed. Right. And so on the EEO stuff, the real question is it job related and consistent with business necessity? And that question comes from a lot of things, even ADA, right? So if you're asking this in your brain, you can go a long way to keeping yourself out of trouble. Now let's talk for a second about that age 18. Hard question, right? So it depends on what you're hiring for, right? Certain things are reportable even if you're a juvenile, right? And so driving records, for example, doesn't matter if the person was 16. If they got a ticket, it's going to show up in their motor vehicle report, right? So driving records are always considered an adult thing, right? Um, Depending on the state, there are other things that may bump you up to an adult if you're underage. Typically, in North Carolina, you're talking about the most severe crimes, right? The murders and that sort of stuff. If you're a murderer, you're going to get bumped up to adult court. It all passes through juvenile court first, but you're going to be tried as an adult. The juvenile court and the judge involved with the juvenile court has the right and the ability to bump up any crime to adult court, right? For a 16 or 17-year-old. So North Carolina was the very last state to change adulthood in the criminal record world, um, from 16 to 18. And that went into place December of 2019. So today, if you're looking at somebody who is a juvenile, they probably do not have a case in adult court, right? If they did something really stupid like murder, they're probably still incarcerated. But there's wiggle room there, right? I would say what most companies do with people who are under the age of 18 is that they forego the criminal record and they get uh, letters of recommendation instead. Right. So in the lack of criminal records, then you have to fill that with something else. And letters of recommendation or references can certainly be a good substitute for that. If they're under the age 18 and they're driving or something like that, that will be reportable, then you still have to get consent and go through the process. Remember that in North Carolina, someone under the age of 18 cannot sign for that. That all has to be countersigned by a parent or guardian. The unfortunate thing is in North Carolina, they can revoke their signature at any time too. So just something to think about. Did I answer that 18 and under question? So are there any other questions on that?
We have one more question in the chat. If someone is working with Catapult's background service, do we send the adverse action automatically to employees?
So if you're using our system, it's very easy to send that, but we don't know if you hire or don't, right? That's something that you have to initiate yourself. And so from our system, it's just one button push. You'll go in and look at the report, and down below the report, there is a um, um, disclosure and forms section in a pull down menu. And you would select pre adverse action packet. And then you would punch the button that says email, and it would send it out to them. So you have to, the business, you, the employer, have to manage that because you're the only one to know if you're hiring or if you're not. Hope that answered that question. Are there any other questions before we move on? All right, let's just talk. There's a lot of stuff that's sort of happening right this minute. And so there are a lot of hot topics around this stuff right now. PII, PII is personal identifying information. That's things like your social security number, a PIN number, your mother's maiden name, those things that are used to identify a person. That is a very hot topic right now. And we have executive orders out of the White House. We have a lot of rules around data breaches and data handling. And it is just a super, super hot topic. This single topic is what's been driving the Consumer Financial Protection Bureau, which is a special agency that does not have congressional oversight, who has just passed all the litmus tests with all the way up to the Supreme Court that they are a valid agency with control, and they are taking advantage of it. And so we'll talk a little bit more about the CFPB in just a second, but you have got to take steps to protect your employees and your applicants' personal data. Marijuana is obviously a hot topic. Washington and California made some new rules this summer on how you have to test for marijuana. Um, Interestingly, was a huge study done, released by Quest Labs with over 10 million um, drug test sample for their survey, and they have found that the applicants out there now are 6 times more likely to try to cheat their drug test than in 2022. So huge change on people trying to either dilute or some way obscure their marijuana use. Um, it is a hot topic. Matter of fact, I was just interviewed by a TV station in Charlotte about this a few weeks ago. Um, where should you land on testing for marijuana? I mean, it boils down to uh, a risk assessment for your company, right? There's a new study that came out at the beginning of 2024, beginning of this year, that said that workplace injuries are up 10% because of marijuana use, right? So if a place has um, if a state has recreational or medical marijuana, those companies have a 10% increase in their workplace injuries, right? So something to think about. Those workplace injuries cost you, the employer, money, right? That's a cost being borne by the business. So something to think about. Um, Accuracy, background checking accuracy is always a hot topic. The CFPB has been on the warpath on this for about a year and a half now, 2 years. Um, like I said, we just had a new summary of rights from them that went into effect earlier this year. We had last year CFPB issue a press release announcing new rules. They just came out with some stuff on October 24th of this year, talking about it. Really, really interesting stuff. No final rules yet. Uh, they went through their small business program on getting feedback. Um, the consensus is that the CFPB was rather opaque in what they're planning on doing. Um, However, it looks like that they are going to restrict some of the permissible purposes that you as an employer might have to look at a background check, right? So we'll see. There's going to be a change in Washington. So who knows what's going to ultimately come out of it. But I think that the consensus right now is that stand by in the next month or so and see what happens. Um, we also have a continuing movement on the ban the box stuff. Ban the box originally was to remove the question from your application, have you ever been convicted of a crime? Those have pretty much all morphed into second chance laws, which either postpone an employer's ability to do a background check or restrict it in some places like New York City. So the ban the box thing is just the theory behind that is that you as an employer should get to know the applicant first before you discover about their criminal past or their history. Um, and the thought is that hopefully will allow you to give more people a second chance at employment and re-enter the society, right? Ex-convicts re-entering the society. So these are all hot topics. Um, LA just changed their ban the box rule. Um, Washington, D.C. did too this year. So it's not growing across the country like it was for a while. We had one city in South Carolina uh, implement that or try to implement that last year. And then it was deemed to be not legal what they wanted to do. And so that was undone. North Carolina, you don't have to worry about it. Our state law prohibits uh, cities and counties from impacting private employers' ability to do background checks. Um, if you're a public employer, there's some different rules on that. You all know about Catapult. We have a lot of stuff that can help you in the pre-employment service line, and glad to always answer questions. We do have some neat stuff coming up here in the future. We have workplace trends for 2025 coming up on December 10th. We have our HR Resilient conference happening in Greensboro in April. That is our large HR management conference that we have every year. Well worth the time. Um, Here is my contact information. Uh, Feel free to email me or call me. That's my direct dial number. I'm glad to spend some time with you and answer your questions on a granular level. Right, that's what we're here for. Uh, Joni, were there any other questions in chat?
No, we have no other questions right now.
So I would encourage you to ask questions. Now we have a couple more minutes. I'm like I said, you can always pick up the phone and call me too. I'm glad to talk to you on a one-on-one basis. We always have our HR advice line and our legal help through the Sewell Law Firm. If you have something that is uh, that nature, feel free to email me. Also, if you're working with us, you know that you can talk to Bree Early or any of our staff. They are all advanced certified for the Fair Credit Reporting Act. Um, I hope everybody got something out of this and had a useful time spent. If you have any questions, I look forward to hearing from you. Thank you all so much.